Okay, we're back on the record this morning. Ready to call our final case of the morning. This is an interlocutory appeal from Johnson County. Case number 127136, Creative Planning, LLC, appellant cross appellant versus Stephen Greco and Spotlight Asset Group, appellants cross appellees. If the attorneys, you're already here, if you could please state your appearances.
Good morning, Your Honor. This is Terry Campbell, and with me is Aaron Levy on the briefs for the appellant cross appellee, Stephen Greco and Spotlight Asset Group.
Good morning, Your Honors and counsel. Melissa Sherman here for appellee and cross appellant Creative Planning. I also have here with me Creative Planning's Chief Compliance and Risk Officer, Lee Richardson.
Thank you. I would like to note that we would expect the appellee cross appellant to address the cross appeal during the argument without additional rebuttal unless the parties have otherwise agreed on another practice.
That's what I anticipated, Your Honor.
Okay.
We're comfortable with that. We're certainly happy to answer any questions that the panel may have after rebuttal if there's need for that.
Okay, thank you. Would appellants like to reserve any time for rebuttal?
Reserve 3 minutes, please, Your Honor.
Okay, granted. All right, you can begin when you're ready.
Thank you. May it please the court. I want to sort of start and finish, hopefully finish with this. This is an old case. Like, it's not as old as the case you just heard, but for a civil case, it's really old. For a case under the Anti-SLAPP Act, which is supposed to be heard within 30 days and decided expeditiously after that, it's really, really old. The case was filed in June of 2020, so it's over 5 years old. We filed the anti-SLAPP motion in November of 2020, so it's about 55 months, a little more than 55 months since we filed the first anti-SLAPP motion. I think no reasonable person can look at what's gone on so far in this case and say, this is what the legislator wanted to happen. That's the Anti-SLAPP Act. Let's talk about the reasons why. First, the background of the case. The court knows about this. Is an interlocutory appeal in the Anti-SLAPP Act. The claims are, in the petition at least, for Mr. Greco's speech to reporters. There was a breach of contract claim. There was a tortious interference with business relations claim. There was a defamation claim, tortious interference with contract, and conspiracy. Those last three, I think the court understands, were dismissed. So on the direct appeal or the direct interlocutory appeal, the only issues, the only claims that remain for this court's consideration are the breach of contract and the tortious interference. I think it's also important for the court to understand it, for me to make clear from the beginning that we didn't attack all of the breach of contract claim. There are some claims for poaching employees and things like that. We don't think those have any value. If they want to pursue those when all this is over, fine. But we're attacking the speech-related aspects of the breach of contract claim and the tortious interference claim. Plaintiff's petition didn't allege the particulars of what Mr. Greco said. It said he spoke to reporters, reporters contacted us, and the reporters are pitching a story that we don't like. We found out later that the plaintiff didn't really know anything about what Mr. Greco had said, other than what you've seen in this email from Ian Wennick. So what did we do? What did they do? They asked for discovery. We opposed that at every step of the way. And you've seen all the briefing and the places we opposed that.
You file a motion to dismiss.
What's that?
You file like a 12B6 or a 60 for motion to dismiss based on inadequate pleading? No,
we filed a motion to dismiss under the Anti-SLAPP Act, KSA 60-5320, which is not, it's sort of a precursor to Rule 12. I anticipate we'll still file potentially some Rule 12 motions. I'll call them the plaintiff, has also raised this issue about personal jurisdiction. I think personal jurisdiction is waived now. In the district court, my client filed a separate suit related to counterclaims that he would have had to brought if he'd answered this case. So personal jurisdiction is, I think it's waived anyway. But we did not file a Rule 12 motion, so we did instead file the motion to strike. And that has to be filed even, there's a time limit to file those, and we met that. What's the purpose of Anti-SLAPP Act? I think maybe Judge Isherwood is the only one of you that has sort of had at least an unpublished case on this. I wasn't sure that the other two of you had, but the purpose is to weed out cases where the plaintiff's purpose might be to stop the defendant from speaking on public issues. And the legislature provided an expedited process for doing that, and we attempted to use that expedited process. And it's a two-step process. The first step is the respondent, the defendant in this case, says, I was speaking on a matter of public concern, and there's statutory definitions about all that. It's speech made in connection with a public issue, and public issues defined to be issues that are relating to goods, products, and services within the marketplace. Clearly, he was speaking about creative planning services in the marketplace.
I don't want to mess up your flow. We definitely know what the Anti-SLAPP Act is and its purpose. So in filing a motion under the Anti-SLAPP Act, though, you have to assert that you're making a certain type of speech and that speech is protected, right? And so then in asserting that, you have to establish that the speech is protected. So you'll have to say what the speech is.
He did say what the speech was. He said what he was speaking about and what it related to. And his affidavit, it's at record 12, pages 44 to 45. That's his affidavit where he describes what he was talking about and why it complies or fits under the statutory definition.
Okay. And so
that he went specifically into what he said, but I don't think that's necessary in the statute.
So you think that under the statute, you could prove application of the Anti-SLAPP Act without saying what was said?
I think he did say what he said. He said, I don't remember exactly what the affidavit said, but it goes very specifically into what he said, at least the import of what he said and why it complies with that statute. I think that's all that's required. That's certainly Judge J. That's all that's required.
Okay.
And so a verbatim reference is not required.
Right.
It is your position.
Right.
So I have a question generally about your motion at the way it's worded. You assert that had the court not wrongly permitted excessive discovery, the motion would have been granted. Is that the assertion?
That's the claim, yes.
So let me ask you this. If we review this case using all of the information available to the district court, is it your assertion that it was wrongly decided based on the information available to the court?
I would say that if the court was permitted to consider the erroneously granted discovery, then that's not the subject of this appeal. In other words, we'll contest the merit of that at the trial court level. I think we'll win at trial, but that's if this court concludes that discovery was proper, then our appeal goes away.
Okay, so you are not, so you are not appealing the denial based on the available facts.
We're appealing
Evidence.
the denial. We're appealing the denial of the motion because we believe the district court considered facts that it shouldn't have considered.
Okay. So I'm having some difficulty because this is an interlocutory appeal, so it's procedurally different than if we were reviewing a summary judgment, for example. From
My apologies, Your Honor. Very similar, though.
what I can
think.
tell. There are some similarities, although we don't typically at this stage review a denial of a motion for summary judgment. So in reviewing this, I'm curious as to why we get to decide that the court erroneously applied discovery rules in an interlocutory appeal.
Because it goes directly to that point that you're asking about, Your Honor, and it is because either the court was allowed to commit to consider this, what I'll call after acquired evidence, or it was not. And if it was, then at least the denial of the anti-SLAPP motion was correct. It doesn't mean that plaintiff's case has merit. It just means that we weren't entitled to anti-SLAPP relief. If the court instead was incorrect in granting that discovery, then the court should not have considered that after required evidence, or this court can grant relief in the sense that telling the trial court, go back and reconsider this without that after required evidence. And I think the only proper outcome, if the court doesn't consider that after required evidence, is the granting of the anti-SLAPP motion.
Okay, so in an interlocutory appeal, though, we don't usually rule on court's discovery orders.
Correct. In this case, it's appropriate for the reasons we've described in the briefs, and it's because the court considered this after required evidence and it shouldn't have. That's the basis of our appeal.
Well, that could be the basis of any appeal of any interlocutory appeal, though. Any summary judgment interlocutory appeal, for example, that the court wrongly applied evidence. Why can this not be brought up later?
So there's no interlocutory appeal of summary judgment denial. This is a special.
Well, there's a motion that can be made for such.
I think this court would summarily deny that appropriately. In this case, the legislature granted a specific form of interlocutory relief. So that's what we're dealing here. The legislature said the Anti-SLAPP Act is so important that interlocutory relief is appropriate for the denial of an anti-SLAPP motion. And it also said discovery is extremely limited. You have the statutory language, but I'm paraphrasing, in anti-SLAPP situations. What we had with Judge Gurney was he said, we know what discovery is. Discovery is, there's good cause for discovery if I raise my finger to the air and it feels like a good discovery kind of a day.
Well, that's not what he said.
That's not what he said. But he said, you know what he said. I don't remember the exact words. But he conflated the concept of good cause with the concept of relevance to the anti-SLAPP motion. Those have to be two separate things because they mean that there's two different sort of words in the statute. If they mean the same thing, then they don't mean anything different than regular discovery. It has to be relevant to the motion. Okay, well, that's not any limitation. I don't think, and this is why we're still here 5 years later, that's not what the legislature intended. The legislature intended to be much more limited.
Relevant to the motion, but not necessarily relevant to the entire case. Is it your intent? Is it then your contention that the discovery was not relevant to the motion?
I'm saying that discovery was relevant, at least portions of it were relevant to the motion, but it was way overbroad. And more importantly, there was no good cause for the discovery because the allegations in the plaintiff's petition weren't enough to get us there. Let's talk about how these kinds of motions are, many courts have held similar to qualified immunity cases. Judge Coble, you would have dealt with perhaps qualified immunity cases when you were in the federal system on motions to stay discovery. You don't get discovery in the federal system on a qualified immunity motion if you just allege, well, I think my Fourth Amendment rights were violated. I need some discovery to figure out exactly how or why that was a clearly established violation of law. You don't get that in the federal system. My point here is simply saying in the state court system, when we're talking about the anti-SLAPP motion, it ought to be roughly the same. If you just allege, I think the defendant said some things that I don't like or that are defamatory or that are disparaging. I don't know what he said, but I need to go find some discovery about it. I don't think that should be allowed.
Well, except that your client brought in the specifics of what was said by asserting anti-SLAPP.
He said, generally, this is what I was talking about. And either they have the evidence to prove their case when they file it or they don't. And that's the point. And so, it's the same as a qualified immunity motion. The defendant in a qualified immunity case says, I have qualified immunity. Yes, I arrested this guy, but I had probable cause to arrest.
Except that there's more steps than anti-SLAPP. So it's not just, okay, does the statute apply? Then there's more steps that the district court has to do. And so in qualified immunity, does it apply? Yes or no. So we have step one, statements, did they whatever. And then step two is, but is there a likelihood of success? And so how can the court determine step two with no evidence?
It's the exact same thing as qualified immunity. You don't get that evidence if you're the plaintiff in a qualified immunity case. You don't get that discovery. You have that burden, just like you do in the anti-SLAPP context, but you don't get that discovery unless you allege a clearly established violation of constitutional law.
We're technically over time, counsel, but something maybe to think about in rebuttal is it seems like the briefing has focused a lot on how overbroad the motion for discovery was, but doesn't focus so much on the end result of that motion, which was a significantly narrowed set of discovery requests, and also discovery then propounded by you. And so I'm wondering then, what is your argument as to that narrowed, the end result of that, all of that narrowing, was that narrowing insufficient?
Refer back to my opening remarks, which is this is not what the legislature intended. The legislature didn't intend for the plaintiff to say, I'm going to throw this much up on the wall and maybe some of it will stick, and then we'll narrow it some, and then we'll force the judge to narrow it some more over several months on a process that's supposed to be decided within 30 days. And whatever time I have left, I have to say, please.
Thank you.
Morning. May it please the court. This is a case about enforcing contracts and preventing parties from relying on arguments, rights, and legal procedures they have waived to continue disparaging and defaming a former employer and competitor, which they had contracted not to do. Kansas courts have long recognized that they have a duty to enforce contracts as they are written, and that's the word that the Kansas Supreme Court has used as far back as 1978 in the Fourth National Bank case that we cited in our briefing. Court said the duty of courts is to sustain the legality of contracts unfairly entered into and enforce them as they are written. Here, Creative Planning is asking the court to recognize and uphold defendants' contractual waiver of any claimed right to rely on the Kansas Anti-SLAPP Act, as well as the invited error and waiver of any arguments related to the discovery permitted by the district court. Creative Planning is also asking this court to protect its rights to file and pursue meritorious claims, which is also part of the Anti-SLAPP Act. Council mentioned the purpose of the act. What you didn't hear was the statute specifically also indicates that it is necessary for the court to also protect the right of parties to bring meritorious claims.
Okay, so you obviously know that you're in an interesting position here of sort of cross appealing and an interlocutory appeal.
Yes.
Okay, so one, let's start with your arguments refuting the discovery contentions, because I believe you get to make those arguments, and then we can figure out if you're allowed to make other arguments, or we can talk about that. So can you start there?
Absolutely. And many of these arguments also are important to the cross appeal, which is why we believe the court has and should exercise jurisdiction. First issue, Your Honor, is that defendants have waived any right to rely on the Kansas Anti-SLAPP Act. And I will tell you that the district court here did not really even consider the issue, just simply said, I understand that, you've argued that, and I'm just not going to find that. There was no analysis, no discussion as to why the court was not going to treat the cases that have recognized waiver under these circumstances. There was just simply.
Okay, but I think that the issue of whether or not you can argue that right here on appeal, we haven't.
No, that is an alternate basis, Your Honor, for affirming the court's decision with regard to the denial. So we believe that it is an appropriate argument with regard to the issue raised on the appeal.
Except I think counsel has said they're not appealing the denial. as is. They're appealing only the discovery issues.
But that relates to the ultimate issue there is the denial of the motion. Effectively, the argument is the court should not have granted discovery. If the court had not granted discovery, then the motion would be denied. So that is what
I don't know if the motion would be denied or not. I mean, I guess the court would have to determine if the motion would be denied if there was no discovery. So let's skip the waiver part. Let's go to the discovery argument. We can come back to the waiver.
So on the discovery argument, Your Honor, Kansas courts have long applied the abuse of discretion standard when considering discovery issues. It's a tale as old of time in Kansas courts. Good cause is the standard. There's been lots of courts or lots of cases that have discussed what constitutes good cause. Those cases were in effect when the Kansas anti-SLAPP statute was enacted. Statute used that term good cause, and this court has found, and there is a specific Kansas statute on rules of statutory construction, that when you use legal terms of art like that, they should be read in keeping with how those terms have been used previously. So we've got to start in the appropriate place, which is the standard of review is abuse of discretion. And I also, Your Honor,
would it though, but if it's abuse of discretion, then wouldn't it be a de novo review of whether or not the court appropriately applied the law in defining good cause?
No, I don't believe so, Your Honor. The issue is still good cause. What constitutes good cause? And the court has found repeatedly that good cause comes with broad discretion, meaning that the standard is abuse of discretion. And we see that from California courts, specifically the court in Schrader, 97 Cal App 4th 174, found that we may not disturb the trial court's ruling on discovery requests in an anti-SLAPP Act case absent an abuse of discretion. The California Supreme Court or California Appellate Court made the same ruling in Bala, 59 Cal App 5th 652. Abuse of discretion is the standard. Texas court in Walker versus Zion 420 Southwest 3rd 454 applied the same abuse of discretion standard, meaning the court has broad discretion as to whether to grant or deny a request for discovery.
Well, no, the abuse of discretion standard is an error of law, an error of fact, or unreasonable. That's the abuse of discretion standard in Kansas. So here the question is, do we have an error of fact? Do we have an error of law, or was it wholly unreasonable? Wholly unreasonable, obviously, lots of discretion for the district court. Error of law, less discretion. So do we have an error of law in how the court applied good cause?
Your Honor, no. The court specifically found that good cause existed, and not for the reasons that counsel represented, but because it was important to get to the facts at issue in the motion to strike. With the point that Your Honor raised, my client did not know the specifics of the statements that were made because they were made privately. Two reporters communicated to my client secondhand. There's evidence in the record that my client asked those reporters what specific statements were made to you, name your sources, and those reporters refused to do so. That in and of itself constitutes good cause. Defendants raised the issue of protection under the Anti-SLAPP Act. And as Your Honor acknowledged, we can't even get to a place where they can demonstrate that the act applies unless we know what the specific statements are. And generalizations in an affidavit do not equate to specific statements. And that's what we had in this case. Generalized statements that I talked to them about, my whistleblower filing, that's it. There was no mention in the affidavit of what actually came out in discovery, that there were statements made to reporters that my client had unmanaged assets that were being reported as a part of the assets under management, and many other similar type statements. Those specific statements were not referenced in the affidavit. But we've got to get to the heart of what those are before we can really dive into the Anti-SLAPP Act motion and before my client can properly defend it, which is the entire purpose of discovery in a case like this.
But isn't that's taking a really broad view of the statute's narrow and expedited process, right?
I don't believe so, Your Honor. We specifically took the position that we were happy to engage in expedited discovery. We tried to move the discovery forward as quickly as possible. And I would stop and just say, counsel started with the comment that this case is old. What you didn't hear, though, was that defendants' actions contributed to a lot of the time that has been spent in this case. Specifically, there was a writ filing in this case challenging the issue that you're again being asked to consider today. That writ was denied. That took a tremendous amount of time just on the writ. And then we also had defendants in this case seek their own discovery, and not just seek their own discovery, but file motions to compel on that discovery, involve a special master who incidentally was Mr. Cronowiter here in the court today. All of that was at issue and delayed the process. So for defendants to come in here and ask the court to, look to the speediness that the court is supposed to be applying and following cases like this, it's disingenuous.
Can we even get to this discovery issue in an interlocutory appeal? Why can't this be handled at the end of the case?
I think that's an excellent question, Your Honor. And I would say, when you asked it, I thought to myself, I wish I had thought of that in the briefing. But the fact of the matter is, the statute allows for an interlocutory appeal of a denial. It does not specifically allow for an interlocutory appeal as to the grant or denial of discovery. And defendants can't have it both ways. They're arguing on the cross appeal that we don't have the ability to appeal because we're not specifically permitted to do that. Well, likewise, there is no specific appellate right in the statute for the court to consider the issue of a grant or denial of discovery.
Okay, so let's talk about why you think you should get to appeal an interlocutory appeal in this position.
Sure.
I will say I'm skeptical, find it dubious. So you make the waiver argument, but I don't know why we would get to address that, because the statute says we can address a denial by the movement.
Okay. Thank you for your question. And firstly, as I said, our position is the waiver argument is directly applicable to the first issue, and it was treated as such in the briefing, which sort of supports the argument that we've made for jurisdiction. So we do not dispute that there is no specific statutory right of appeal for the grant of a motion to strike in this instance. We don't dispute that. It is what it is. However, this court, or the Kansas Supreme Court and the United States Supreme Court, has recognized the doctrine of pendant or supplemental interlocutory appellate jurisdiction. So when there are issues that are inextricably intertwined with the issues in the appeal, the court treats them together. So for instance, in this case, we have argued that there is a contractual waiver such that defendants are challenging the court's decision denying their motion to strike. What they're asking for is for your honors to overturn that decision. We are arguing that they can't make that argument because they don't have a right to rely on the Kansas Anti-SLAPP Act in the first instance. So we shouldn't even be talking about.
But if we overturn the denial, it goes back to the district court, and then you can make this waiver argument to the district court.
We certainly could, Your Honor, but your review here is de novo. We would ask for you to handle it here. And with respect, the Court of Appeal, or the district court, has already taken the position that he's not going to really consider that. So the court has already passed on that issue and just indicated that he wasn't going to find a waiver. And that is notwithstanding the overwhelming amount of cases across the country that have recognized a waiver in these circumstances. In fact, we have not found a single case that is treated or that is considered fact similar to this one, where you've had an agreement not to speak, not to petition prior to the litigation, and the court has found that there was not a waiver. In all instances that we have found on
But wouldn't you be able to
been a waiver.
Wouldn't you be able to appeal that at the end of the case? Or you could certify the question to come up. There's a statute that allows interlocutory certification of questions.
We certainly could, Your Honor. Absolutely. But We again, based on the court's de novo review, would respectfully ask your honors to find that the court properly denied the motion to strike as to counts 1 and 2, because plaintiffs or defendants don't have the ability to rely on the anti-SLAPP statute because they've waived it.
Okay.
So with regard to your honor's specific question as to jurisdiction, there's a TNT case that defendants have cited. We appreciate that they're probably going to discuss that on rebuttal. With respect, that case was unpublished. Also, with respect, it does not appear that this pendant supplemental interlocutory jurisdiction argument was raised in that case. So the court did not have the ability to consider the issue. Respectfully, the issues in this case that we are raising and the cross appeal are inextricably intertwined with the issues raised in appellant's appeal. For the reasons that we've stated in our brief. And again, you can see it just by looking at the briefs and putting them side by side. We've got arguments made on both the appeal and the cross appeal, and incorporating by reference arguments made in the appeal and the cross appeal without any need to explain why that's appropriate. It's because the issues overlap and intertwine in all respects. And another example is whether defendants met their burden. Same issue. And for the same reason, we believe that the motion to strike should have been denied as to all the counts.
Except that I could see, I think defendants bring up issues related to counts 1 and 2. So I don't know how your appeal of the court's decision as to counts 3 to 5 would be intertwined.
Because respectfully, the issues that we raised with regard to waiver, defendants' failure to meet their burden, and our the creative planning meeting its burden are similar and intertwined in both the appeal and the cross appeal.
You have about 1 minute left.
Thank you, Your Honor. Want to briefly touch on the issue of estoppel. As one of your honors pointed out, defendants in this case did in fact introduce and rely on evidence that they produced in the case and that they're now saying should not have been permitted. This court has found, the Kansas Supreme Court has found that a party may not complain of rulings or matters to which it has consented or take advantage of error that it invited or in which it participated. We have that in spades here. Defendants, again, not only ask for discovery when I couldn't find a case where it was allowed for defendants in an anti-SLAPP Act case. Nevertheless, defendants asked for it, received it, and took extensive discovery, going so far as to file a motion to compel, participating in argument with a special master, and then specifically seeking discovery from a third party unrelated to this matter. Under those circumstances, and then specifically when they went ahead and used that discovery to advance their position on the motion to strike, they should not be permitted to argue that there was any error with regard to the court allowing discovery in this action. So, unless the court has any other questions, I will be finished. Thank you.
Thank you.
Ask the court to read the contract, the settlement agreement that Ms. Sherman says is a waiver. It waives, Mr. Greco waived his right to disparage. He didn't waive his right to speak. She said, I think several times in this oral argument that he waived his right to speak. He did not. He also did not waive his rights under the Anti-SLAPP Act. There's nothing in that agreement about the Anti-SLAPP Act, even though it was entered about 1.5 years after the Anti-SLAPP Act came into existence. How does a defendant raise the question of whether or not his words are either defamatory or disparaging without this process? That's what the legislature set forth. There's absolutely no waiver. And I think in order to get to a waiver, this court would have to overturn Judge Klein's decision in the Doe case or somehow deal with it. Please give district court some guidance on discovery so this doesn't happen again. We shouldn't be 5 years down the road in an anti-SLAPP case trying to figure out what evidence can and cannot be considered. Also, most of the time, these anti-SLAPP cases come up in the context of a defendant who doesn't have the resources to protect itself in the same way as Mr. Greco. And so that's another reason why I think this court needs to give some guidance to district courts as to where the discovery lines should be drawn. The reason we did discovery is because Mr. Maluk filed an affidavit the morning of the hearing we were supposed to have on June 10th, 2001. We didn't get another hearing later until I think it was November or October, maybe of 2023. If they hadn't kept trying to add to the record because they hadn't done their work when they were supposed to, we still wouldn't be here. And it all relates to this discovery. So please give that guidance to district courts. Anything else? Thank you, Your Honors.
Okay, thank you. All right, the case is now deemed submitted for decision, and we'll take the case under advisement.